I'm George Whipple, one-on-one with Jill Bigler. I'm with Jill Bigler from our Columbus, Ohio office. Jill, welcome. And you are both a litigator and an advice and counsel lawyer. I believe, as a litigator, that litigation informs every separation agreement I draft, every employment contract I draft, because I've litigated most of the words in those agreements. I change them all the time. How does being a litigator influence your advice and counsel?
I would say it heavily influences because, to your point, I've litigated that issue and I see what the end of the story looks like, how the movie ends. I've seen it. And so to be able to draw on those experiences to say, okay, if we go this path, this is how I think a court's going to interpret that. I think it gives you experience to draw from that's beyond what the law says, what the statute says. It's the practical side of it. I see it a lot, I would say, in the accommodation, the ADA context, because that is such a gray area and it's going to be judge dependent and court dependent. And so I can counsel my clients and say, okay, let's go through this interactive process. You get that demand letter. You set up a call and you have that discussion with the client and you let them tell you the story. You don't go immediately into, well, here's your risk, here's this, here's that. You have to give them time to vent and feel heard and then walk through, okay, here's where I see, you've got some strengths here. We've got a good defense on that, but we might have some areas of risk. And, then just walking through the litigation process.
One of the things I found most engaging, and one of the reasons I enjoy employment law so much, is frankly the emotional aspect of it. It's a very emotional, people-oriented practice. How do you deal with the emotions that oftentimes the plaintiffs are feeling towards the company, and sometimes the company is feeling towards the employee?
You have to hold space for your client's feelings. And there are certain cases where maybe it's a smaller business or maybe it's a higher level exec who left, and there's a lot of emotion. And I think emotion can sometimes drive cases in places maybe they shouldn't go. And maybe it's the plaintiff who needs to process them. And sometimes in those instances, I tell the client, we're going to have to litigate this for a little while. We're going to have to maybe do some discovery, let them vent, say their piece, and, again, try to help them understand, let's hold space for our feelings, but then let's take a step back. And what is the best business decision to make here?
What I found as a lawyer who just believed in wiping out the opposition, I didn't think I'd ever be a convert, but I'm a convert to mediation for exactly the reasons you described. It allows the plaintiff and the company to express their emotions to a third party neutral.
Yes.
And that allows the venting of those emotions. And sometimes after that venting makes it easier to reach an economic solution. Have you used mediation? Do you think that's a useful process?
Yes, absolutely. Again, it helps resolve things before they escalate to a place where it's so costly and so disruptive to the organization. I've had many mediations this year and have had that experience where a plaintiff just wants to come into a room and say their piece. We generally on the defense side don't usually make the opening statement because it can really escalate tensions. But the plaintiff usually wants to say their piece and they want to say it in a room with their former employer. And I do find that in those instances, they feel like they've said their piece. They can get it off their chest now, and maybe they are open to resolution in those situations.
Talk to me a little bit about your background. How did you get to law practice? How did you get to the EBG Law office in Columbus, Ohio?
Started practicing in Northwest Ohio when I graduated from law school. Went immediately into the employment space, practiced there for about 5 years, and we picked up and moved to Columbus. Employment group was small, and then we started looking at other options. And that was really so that we could better serve our clients. One of the biggest things that we noticed when we transitioned over was how much easier it was to practice on the platform at EBG. And what I mean by that is, instead of working in a group of, say 5 employment lawyers, we've got 125 employment lawyers. And being able to rely on the depth and experience of the other, lawyers at EBG has really been beneficial to our practice. It has been a wonderful transition and to be able to serve our clients better.
What's your best advice for a client in the pre-litigation stage?
Think objectively, try to take emotion out of it.
That's number one.
That's number one.
Get the emotion out of the equation and get to the business aspects of it.
Let's feel it. Let's feel the emotion. Let's, work through it. And then let's think about this objectively from a business standpoint. Does it make sense for the business to fight? If so, let's fight. But if it doesn't, then we can work that out too.
Jill, thank you very much for spending time with us today. And thank you very much for watching. I'm George Whipple.